This is Barry Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to talk about the limitations on replacement cost coverage on a homeowner's or any other property insurance policy, and why courts may never rewrite the clear and unambiguous language of a policy. Because you can never get replacement cost coverage and collect on it if you don't repair or replace the property. In Universal Property and Casualty Company versus Irma, Qureshi and George Guerrero, the Florida Court of Appeals on July 24, 2024, was required to address the measure of damages recoverable for breach of a replacement cost property insurance policy. A jury had awarded the insureds $57,836.83 in damages on their claim that Universal Property and Casualty Insurance Company breached some but not all of the coverage terms of the insured's property insurance policy by paying them only $10,000 policy limit for damage caused by mold, without including payment for the damage caused by the water leak at the property that resulted in the mold. The insureds never repaired the damaged items described in an estimate they had submitted for reimbursement from Universal prior to selling their property or at any time after the loss. The policy, of course, required actual replacement before an insured was entitled to replacement value after a loss, provided that Universal would not pay any amount for diminution in value defined in the policy as any reduction in value of any covered property prior to or following repair or replacement as compared to the value of that property immediately before the loss. Universal argued that the trial court reversibly erred by allowing the insureds to introduce into evidence at trial the estimated repair costs for work that was never performed. Courts have almost universally and uniformly held that an insurance company's liability for replacement costs does not arise until the repair or replacement has been completed. In my 56 years in the insurance business, I've only seen one policy that allows for recovery of replacement costs without actually replacing. And the universal policy was not the one. In addition, courts without dispute are not authorized to rewrite clear and unambiguous contracts. The Court of Appeals concluded that the insured's policy was clear and unambiguous. The insureds were not entitled to repair costs unless and until work is performed and expenses are incurred. Well-established Florida law rejects an expansion of insurance coverage to include payment for estimated but not yet incurred repair costs because it would improperly create insurance coverage by waiver or estoppel. The court therefore concluded that because the trial court improperly and impermissibly allowed the jury to consider evidence of estimated but not yet incurred repair costs in determining recoverable damages, the Court of Appeals reversed and remanded the case for a new trial on the issue of damages. On remand, the trial court was directed to confine the proof at the new trial on damages to only those damages for which recovery is permitted under the policy's clear and unambiguous language. In my opinion, courts have sympathy often for insureds who incurred damage but were not paid in full, because as with Irma and George, because they sold the house without completing or expending any money to do the repairs for which they had submitted an estimate. The policy and the law required that the insureds only receive replacement cost funds if they actually spend the money. They did not, and the court had no right to change the policy terms to allow them to obtain funds from their insurer to which they were not entitled. Of course, they could collect the actual cash value of the damage, but did not apparently seek it. In my opinion, this was an error that will probably be cured on retrial. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,800 blog posts. You can also subscribe without charge to the videos on YouTube and on rumble.com, and if you do, I'd appreciate it if you click on the like button for YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. And please tell your friends and colleagues about this blog and videos so that they too can subscribe. Thank you for your attention.